My hands stable, I feel able to turn the tables, I could do this. Just keep moving, keep your hands up, stupid. I feel lucid, a new viewing. I can see the end, I can see my future, I can view it. It's right there for the taking. Everything I've ever wanted, dreams are just waiting. I just gotta fight for it, willing to die for it, willing to like sort of.
Hey, greetings from the year 3000, it still sucks. This is Philip J. Price, and you're listening to the Drunken Turkey Show, your one stop for this sort of thing. Hit that button, like and subscribe. You know what to do, just like every other podcast.
Just like every other podcast. Welcome back to the Drunk Turkey Show. I'm Daniel, alongside with me as always, Big Blue and Hyman. How you guys doing today? Blue, we'll start off with you. I noticed a shirt coming in clutch.
Yes, sir. It's my Drunk Turkey shirt.
I could always tell because it's blue. How you doing, man? How was your weekend?
Good, man. Good. I enjoyed my daughter's birthday. We went to One Pin. It's a new arcade place in North Star Mall. Met bowling, nice. Karaoke, and a ton of video games and crane machines. And you know how the kids are with crane machines. They're going crazy with those right now.
Nice, man. Sounds like a good old time. How was your weekend, my man?
It was good, man. I had a lot of fun. I spent time, with the kids, my girlfriend and whatnot. And I still got that little cough, so like I said before, I'll be muting a little bit more than usual.
Oh, geez. Well, take your medicine, my man. Take your medicine. But today we got a returning guest. We have he's a lawyer. His name is Zach Lutz. How you doing, Zach? Welcome back to the show.
Hey guys, thanks for having me again.
No problem. We're looking forward to having you back. So how have you been since the last time we spoke?
I have been busy. I was in a hearing all day today, like not all day, but like pretty much till lunchtime. Like civil cases, I do civil now. I used to do criminal back in the day, which I don't anymore, but I have done it. So I feel like I have enough experience to consult y'all on what y'all are going to talk about today.
Well, thank you. I appreciate that. Thank you for joining. So we're talking about the 2017 Delphi murders, the double homicide of Liberty German and Abigail Williams. This was they went missing. They've gone on the Monheim Bridge Trail area back in Delphi, Indiana. Went missing for a day. Their bodies were discovered the next day. And the case was unsolved for about 5 years. Mm-hmm. And then an arrest was made in November of Richard Allen. And it was kind of a left turn for a lot of folks who were, following the Delphi case. It was a name nobody had heard. It was a name that, it was somebody who, didn't fit the description, so to speak. I mean, there was a video of a guy, but Richard Allen's like 5'4", 5'3", real small, petite dude. He worked at the CVS store, kind of a average, normal guy.
Average Joe.
Yeah, exactly. Mm-hmm. And he ends up getting arrested, and there's a probable cause affidavit that came out that pretty much references him putting himself at the scene at the time of the incident, wearing the clothes of the same clothing that was the perpetrator that was videotaped by the little girls seen in their tape, wearing the same clothing at the same time, and he puts himself on the bridge around the same time. Mm-hmm. And then there is a unspent round that is found in between the bodies that matches back to his gun, mm-hmm. which I'm going to have some questions about also as well.
Okay.
And so those items, and then there was a couple of eyewitnesses of people who had seen someone that matched the description of the person that was on the bridge that ended up rounding back to Richard Allen. And so for the most part, everybody was like, all right, it seems pretty cut and dry. And then we see pictures of Richard Allen, and he's lost like 60 pounds. And, again, he's like 5'4", 5'3". And, people started wondering, he's saying that he's being abused and things of that nature. And, people started asking questions like, is he doing it to himself? Is something happening to him? He apparently tried to get out of the prison. So he's in prison right now, being held in a prison, not in a county jail.
Mm-hmm.
And so he was trying to get moved out of the prison, moved back into the county jail. The area didn't allow him to do so. And then all of a sudden we get a 136-page document that basically states that Richard Allen is 100% innocent and that there is some sort of Odinistic, ritualistic angle to this. And that also law enforcement have been lying and fabricating evidence. Now, here recently, some crime scene photos were released, and the lawyers have withdrew as being representatives of Richard Allen. The judges accepted, and right now, Richard Allen has no one to represent him, and his court is supposed to happen in January.
Yep.
So, I think that's all caught up to date. I hope I did everything right. I hope I didn't miss anything. So first and foremost, going to Richard Allen's probable cause for arrest. All they had on him, there was no DNA found at his house, no DNA found anywhere. They had done the search prior to his arrest on his house and his car. And they had an unspent round that had extraction marks on it. Have you ever heard or seen a case where that type of markings were used in court as evidence against somebody?
Not personally. That sounds kind of sketch to me, and the reason I say that is because, when you're doing like ballistics data, you fire the gun out of the round, and then the gun hits the bullet hits a target, and that bullet's going to deform, whether it hits a soft body or whether it hits a hard surface. But apparently, it's an unspent round with extraction marks. That just by itself, really doesn't tell me anything. It seems like the prosecution is going off of it's a 40 caliber round, 40 Smith & Wesson, I believe, is the caliber. Again, I don't know. I don't know exactly what's in the prosecutor's file, everything, but
Right.
Just seeing a bullet with extraction marks wouldn't be enough to establish probable cause in my book. If you think about how many gun owners are there that have a 40 caliber pistol, assuming it is a pistol, it could even be a rifle.
Right.
So, yeah, that's my take on that.
Do you think it would be pretty easy to find somebody who can, an expert in the field that could, put some doubt in that type of evidence?
Oh, absolutely. Yeah. Expert testimony is, it's a lot of cook in the books, really. Usually you get dueling experts, our expert's going to testify that the round belongs to the gun, it's unique to that gun. We'll have our expert, the defense expert, say, no, you could easily replicate extraction marks. All the guns basically go through the same manufacturing process. So, it's impossible to determine if that is the specific gun that was used at the murder, or that was the round that was found at the murder. As far as I can tell, it doesn't even look like they were shot. It sounds like they were stabbed. Am I correct on that?
Yeah. The reason why the gun comes up is because apparently, and we haven't heard this, but supposedly there's some rumors out there that the girls took a video, which we know they took a video, and you can hear the suspect say, guys down the hill. And from what we understand is there's 45 seconds more of said video, and then some part of the video, it either shows a gun and or one of the girls says he has a gun.
Yeah.
And when they were looking at other people that they were possibly involved in this case, gun was something that they were searching for in the search warrants, were specifically for guns and knives. So that led me to believe that there was a gun that was possibly used maybe as a control device in this situation, and which would also explain why it was ejected out of the gun if he kind of pulled the slide back as an intimidation tactic to control this person, and it just flew out.
Yeah.
So yeah, outside of that, all they have then they have a camera of a vehicle passing by the trail heading towards the area where he is suspected to have parked at 1:27 a.m., which puts him on the trail at 1:30. These girls took a video at 2:13, and they have a couple of witnesses who had seen him, 3 juveniles who were walking out of the trail, and one other adult female who had began walking on the trail after Allen had gotten on the trail. And basically, based on their testimony, and the 3 juveniles also had taken a picture of themselves, so there's a timestamp as to where they were at, and it was right before, and that was at 1:26. So based on all that puts Richard Allen, if everything is correct, and even in his testimony, on the bridge right before the girls get there. I don't think that's enough. And one of the reasons we find out later is, according to prosecution, is this statement that Richard Allen supposedly made that he said he got there at 1:30. They don't have it. They're going based off of a officer's memory. He supposedly taped it but lost it and didn't have any notes. So yeah, that's the evidence against him. I don't think that's strong enough to arrest him.
Well, I mean, it might be strong enough to arrest him, but to convict him, like, that's, the thing I'm looking at. Probable cause, it honestly doesn't take that much to get probable cause for an arrest. It's what the suspect does while they're arrested that usually leads to conviction, which I'm sure you're going to bring up later in this interview about the confessions and whatnot.
Yeah. So that makes sense. So Richard Allen gets arrested. He ends up going to jail. According to let me backtrack. Mm-hmm. So while they were investigating this, apparently this Odinist angle had came up, where they thought that perhaps there was some sort of ritualistic angle to this, and the reasons being was they had discovered a what appeared to be an F shape on a tree, and there were branches placed on the bodies of the deceased in a certain way that mimicked possible ruins, which were symbols from the Odinite group. Mm-hmm. And their bodies were also placed in a way that Richard Allen's defense team is claiming is ritualistic. All right. So there was apparently 3 officers who went through this, and they they believed that there was also a ritualistic avenue. And apparently there was this entire investigation. Now, according to Richard Allen's defense team, they never got that investigation through discovery. As far as they talked to a couple of folks from the law enforcement did, that is, that were part of this Odinist group in the area. Apparently there was one guy who had confessed to doing it to his sister, and his sister passed a polygraph test as far as him telling her this. And he had knowledge of some certain specifics. And basically there was some evidence that made it look like it was Odinistic. If you were Richard Allen's defense attorney, like, swear it was like obviously you would attack that area, but what do you think about the law enforcement investigation as far as, well, how would you defend it? I mean, I'm kind of a loss for a question. I know what I want to ask, but I can't. Yeah.
I don't really know about this Odinistic thing. Like, I did read briefly about it. Like, the defense apparently has this 130-page document about Odinistic rituals, and I do know that, like, allegedly the bodies were positioned like as Odinistic ruins, and they found the blood and the sticks and all that. But I don't know. I kind of have a hard time believing that this is some kind of conspiracy. I mean, from what I read, it sounds like it's a deeply running conspiracy throughout that community. Like, apparently the police are in on it. Like, they're forcing him to confess to keep either the real killer or whatever secret. I don't know. I'm having a hard time swallowing that, honestly. I mean, if you look at the OJ trial, and like, unfortunately for the prosecution, like the police officers that handled OJ Simpson's arrest may have been racist. So, like, I would have a easier time believing something like that. But some kind of deep Odinistic real ritual, like that's something out of a video game. I mean, I don't. Like, if they have evidence, go ahead and present it by all means. Like, I don't know. I don't know what they have, but
Right.
Like,
well, what they do have is, well, one, a couple of the guards were wearing Odinist and Odin We Trust patches on their uniforms, and they wore them up until the defense team informed the prosecution that they were aware of a investigation into the Odinistic angle, and that they were wanting the discovery on that because they hadn't gotten it up to this point. And then immediately after that, the next time they go visit Richard Allen, those patches are off. Now, the guards have come forward. They've had to testify, and they had stated that they did wear those Odin patches. They're a part of their religion. Apparently, it is a religion in the area that a lot of people are in, and or maybe not a lot, but there are a few, and that they were ordered to take them off after a specific date, which coordinates with when they told them that they were having that when the defense came to the prosecution asking for that information. Now, according to Richard Allen's defense team, Richard Allen had told them that those guards were threatening him, threatening his wife and his children, and they basically were telling him to go and tell his mom or tell his wife that he had committed that he killed the girls. And what the defense team also found was that they went and talked to a couple of the witnesses, and one of the witnesses stated that the person they had seen was wearing a tan jacket and not a blue jacket, which was what the officer had written down in his report and also in the probable cause affidavit. And then another witness stated that they had seen a very young guy and that he was muddy. And what Liggett had put in there, the officer, was that he was muddy and bloody. And, they laid out some of these information that basically would point at somebody else other than Richard Allen. And that was kind of the narrative that they were pointing at. And they were saying that, there was a Odinistic avenue. Now, they even pointed to specific Odinistic persons. One guy was Brad Holder, whose son was dating one of the victims. Another guy was Pat Westfall, who is friends with Brad Holder. They were best buds, and then coincidentally, after February 2017, stopped being friends. And they had another two guys, John Messer and Elvis Fields. And John Messer is who connects Pat Westfall to Elvis Fields. Now, Elvis Fields supposedly wasn't one of these Odinistic guys, but he was wanting to be one. And he told his sister the day after the murders that he had done something and that he was going to go away for a very long time. And then he had told his sister a couple of days later that he had put horns over one of the girls and spit on her face. When he was questioned by law enforcement, he had asked if they had found saliva on one of the girls' faces and if it was his and if he could explain it, if he would still be in trouble.
Mm-hmm.
And so, like, all these things kind of do point to this Elvis Fields guy. And now I know that Pat Westfall supposedly took like a 4-hour polygraph test and he passed it. And I think with Brad Holder, he was at work during the time when the girls went missing. So they had alibis. But as far as Elvis Fields goes, I don't know. But that's what they're basically saying on the defense side. Then all of a sudden, somebody from the defense's team leaks out these pictures of the murder scene. And in my opinion, in efforts to show that it was ritualistic. So
can we rewind back? You're saying the word polygraph. Who is administering these polygraph tests on these witnesses? Do we know?
It was I believe it was the police department there from, or not the police department, but the, I think it was Indiana State Police.
Okay. And typically polygraphs are inadmissible in court. Right. There's just too much room for error in those things. So I don't know much about Indiana's like police protocol, but if that's what they use, like typically those aren't used anywhere. So if that's what's going on, like, I mean, assuming that this person spit on the victim's face, I mean, I would assume that there's DNA evidence that would like link the guy to the crime, you know?
Yeah, there was a rumor early on that there was a fingerprint that was lost or corrupted. And I was talking to a guy who knows some people in there. It wasn't, they suspect it wasn't a fingerprint, that it was DNA that was mishandled or something that ended up getting corrupted. But yeah, and this guy made some crazy statements, but he also said there was 2 other people there. So he didn't say he was there by himself. Mm-hmm. When a lawyer or a defense lawyer comes up with a story like this, and maybe not even the story, but the accusation towards law enforcement that they fabricated, witness testimony or something. What does that defense lawyer risk if the accusations come out to be false?
Risks the entire reputation. That's what it risks. Because the question is like, who's fabricating what? Like are the police fabricating evidence against the defendant, or is the defense team fabricating evidence against law enforcement? And for what purpose? Is it to try to fabricate the defendant's innocence, or is it try to sensationalize and get their name in like publicity, something like that? Me as a lawyer, I would never ever dream of fabricating evidence, and I probably wouldn't even come up on, or assuming for argument's sake that all this stuff came out of the defendant's mouth, like, oh, some Odinistic cults persons put me up to it. As a lawyer, I have a duty to do some investigation into what the client says. If that's the client's position, there's not much you can do but, go along with it. But you do have a duty to do an initial investigation.
Well, their angle is that he's completely innocent, has nothing to do with it. And what ended up happening was they found this investigation. I think so there was 3 law enforcement officers who were basically going down this angle that this was an Odinistic ritualistic thing. And they're the ones who contacted Richard Allen's defense team and basically said, hey, we had this investigation. We still think that these guys are high. You know, there's a more likely a chance that they're involved than Richard Allen is. And so they gave them that information. According to the lawyers, they hid that information from Richard Allen. And they didn't tell him they knew about the investigation. They wanted to investigate it first themselves. So Richard Allen had no idea that there was an Odinistic angle. He went to the defense team after several times that they had gone and spoke to him, where he was starting to change his appearance. He was acting kind of crazy, saying gibberish, things of that nature. And that's when he finally told them, he's like, hey, I think Odinists are trying to get me and they're threatening me or some of that nature. And at that point, they hadn't even told Richard Allen that there was an Odinist angle, and the prosecution hadn't provided them evidence of the Odinist angle. So he was technically unaware of it. So that's kind of what they're talking about in that instance. And then they brought it up later and after the fact.
Okay. So you're telling me his own defense counsel didn't tell him about the Odinistic testimony from these officers. Is that what you're telling me?
That's what the claim is, yes.
Okay. Well, if that's true, what I'll tell you is those lawyers very likely breached their duty to their client. Like, as a lawyer, you have a duty of loyalty to your client, and you can't hide stuff from your client. You know, like, even if you screw up yourself, you know, you can't hide it. Like, hey, look, I lost this summary judgment hearing, or we lost this, or I missed a deadline. Like, you cannot hide stuff from your client. So if it's true they were hiding this kind of angle, that like this exculpatory evidence from their client and not going over it with them, that implies some bad stuff from these lawyers. If that's what's happening, like, that's the lawyer is the servant master relationship. You know, the lawyer is the servant of the client. You know, and if the lawyer starts acting on their own, then like maybe it's in the best interest of the defendant that they withdrew.
Interesting. That makes sense.
Here's one theory that I always think of is Richard Allen has a history of, I guess, a little bit of like he was going crazy. He checked himself into
mental health.
Yeah, he was having some mental health issues before, probably like a year before this. And the guys that were in the Odin religion might have ran into him at a bar that they all drank at. And if they were interviewed days after the case, I'm pretty sure these guys were talking. And it's a small town where everybody was talking about it. So I'm pretty sure he heard somewhere that this Odin religion is being investigated about it. Because it ain't quiet when somebody gets pulled into an office and gets talked to and say, oh, I'm not going to say nothing, because you know they will. And if they drank at the same bar as him,
yeah,
he probably heard it there. So I think he's playing a ruse. I think it's all a mind game, and he slipped up when he accidentally told his wife over the conversations that he did commit the crime. And then right after he did that is when he started again, oh, I'm losing my mental stability. I can't concentrate. They're doing this to me. That's when he started acting up again.
That's true. That is true. Very good points. You know, so yeah, and to kind of bounce off what Big Blue is basically saying is that he feels that he slipped up when he talked to his wife and basically accidentally confessed, realizing they were recording it, and that's when he started going nuts. And he's trying to play that off as that or whatever, and that makes sense. I don't know about losing that much weight in that short amount of time. That takes some discipline. You know what I mean? To be able to do that, regardless of any situation you're in. But I guess when your life is on the line, you know, going back to what these lawyers were saying and doing. What about the fact that these crime scene photos were released to the public from one of the defense team's staff members. Like, what kind of implications could that have on the trial? What can happen because of that, and what should we expect to happen now?
Yeah, I heard about that. Like, that's kind of like the whole kerfuffle as to why we got this postponement. Like, we were set for hearing in January, and now we're pushed out to. I don't think they have set a date yet, have they?
They haven't changed it. They still have it set for January, so I'm sure they'll change it soon. Though.
Well, yeah, the judge said it was going to be changed because they have to appoint new counsel for him. But yeah, like from what I've been reading, from what I've been listening to, it sounds to me like just a simple case of negligent supervision of an employee. Now, we're not entirely sure if it was a current employee or a former employee. Like, it's not clear when this leak was leaked. I will tell you that the profession of law, like, it's not quite as glamorous as people make it out to be. Us lawyers, we screw up, all the time, and the staff screws up all the time. But the problem is, you can't blame your staff if you're the lawyer. Like, the state bar will not allow you to blame. Oh, my paralegal didn't calendar a date correctly, so that's why I missed the statute of limitations deadline. No, I'm sorry, lawyer, you committed malpractice. So, like, the law doesn't look kindly on lawyers that don't supervise their staff. So, kind of what I suspect happened was, like, there's a rumor that the judge was going to take them off the case anyway. I don't know if that's true. Like, that seems like kind of a harsh penalty for the defendant, like holding the defendant accountable for something the lawyer did. Probably what happened was, like, they found out about this leak and, like, all right, look, guys, like, I'm going to call you in chambers and take you to the woodshed here. Like, this is bad. Like, y'all should have had your finger on the pulse here. Y'all should have supervised your employees. I'm in a position where I'm going to have to sanction you for this. And you can, the lawyers probably were able to avoid that by withdrawing voluntarily. So it's like, either you get out of the case yourself or I'm going to sanction you. And it's unfortunate for the lawyers that happened to, and it's unfortunate for everyone. Like, if the defendant is innocent, he's going to be rotting in some jail cell for another year or however, and this family doesn't get the justice it deserves because we don't know for sure if we have the right guy. Now, as far as your question about, like, how is this going to affect the trial, like, if we have private documents from the defense or from the prosecution that are suddenly out there in the public, I mean, that kind of, like, ruins the whole fair trial thing. Because, like, how do we escape the taint of, like, this community? Like, they've seen stuff that they shouldn't have seen. My landlord, he's a lawyer that's been practicing since, like, the 50s. He's got a term that says, like throwing a skunk in the jury box and asking him not to smell it. Once the damage is done, like, it's pretty hard. You can't put the toothpaste back in the tube. You can't unring the bell. So, I understand that the defense has tried transferring venue to another county or something like that. I mean, if that's still on the table, that's what I would be thinking of at this moment. But the delay, we're probably looking about a year and a half, maybe two, like, as far as, like, having this case tried. And then we have a suppression hearing that hasn't even happened yet, like suppression of evidence. So, I mean, the long story short, everything's going to get pushed back, Yeah.
Jaime, you got a question?
Yeah, I was waiting for the mute button to go. I was going to ask Zach, knowing that the lawyers brought up this Odinism angle, and now that they're no longer in the case or in the trial, and let's say you were the new representative, Richard Allen, would you go through that same angle? And if you don't, how would that make your client look to the jury?
Mm-hmm. I mean, personally, I'm very skeptical of this Odinistic angle. Like, I would really want to do my homework before I take this to a judge or jury. So I would make damn well sure I knew what I was talking about before I presented this, like, to the judge or jury. If after like a thorough investigation, a thorough review of the prior counsel's file determines that that is what happened, then by all means go for it, you know. But I would be very hesitant, and like, you know, I need to be sure of what I'm talking about as far as representing the defendant.
Yeah, no, that makes a lot of sense. Now, one of the lawyers, I believe it's the one who had the leak, because there's two lawyers, there's two separate ones.
Mm-hmm.
Are you surprised that the attorney allowed both of them to go, even though one of them wasn't, you know, responsible for the leak? And I think the one that is responsible is trying to stay on, has hired another lawyer to represent them so that they can stay on the case.
Mm-hmm.
So what are your thoughts on this?
I hadn't heard about that, about the lawyer hiring a lawyer, but if you think about it, it's really the same firm, isn't it? Like the public defender's office, you know, like they were working together really closely. So, I mean, if one of them goes, you know, you probably have to get rid of the other. Like the taint is going to extend to the other one by hearing like the evidence or being involved in the presentation of the case. I would imagine that this county's public defender's office is big enough to have another replacement counsel for them. So, long story short, I'm not surprised that they both had to go. Like, I mean, because when you're co-counsel, you're like this, you know, like I'm co-counsel with some lawyers in my office, and it's like we literally get sick of each other, you know, like we're staying here every day talking about this case. What did they do now? What discovery were served now? Okay, oh, they're trying to set a hearing, like blah blah blah, you know. So no, I'm not surprised that that they both withdrew.
Interesting. And now, you know, since both of them withdrew, another guy's going to come in. They get everything that other attorney had worked on. Is that correct? Even the stuff that they did on their own?
So they're going to get open access to prior counsel's file. From what I heard, from what the judge said, they're not entitled to the other lawyer's work product. And y'all probably don't know what that is. I'll inform your listeners what it is. Like, work product is basically stuff I write in my notebook. Like, you know, you see the yellow pads. Not all lawyers have yellow pads, but like whatever we write down, like our notes, attorney notes, like that's work product. And there's a general rule where we really don't have to give that up to anybody under any circumstances, including our own client. And the rationale for that is like lawyers need to be able to think clearly to adequately defend or prosecute a case. And if all of a sudden, like my notes might be discoverable, like to the other side, suddenly, like I'm going to be on handcuffs. I'm not going to be able to adequately represent my client as well as I could if I can't like have notes. And it doesn't have to be handwritten notes. It can be stuff you type up on the computer and whatnot. Like, but it's the lawyer's general work product. So, the lawyers in this case are free to give up their work product if they want to. I mean, assuming they want their client to be acquitted, assuming that the client is innocent, then I would certainly give up my work product, you know, to see that this poor man that's having these false charges gets out. Now, if the lawyers were involved in anything shady, you know, like they might not want to give up their work product, you know, because it might have something incriminating on it. Not saying that there is. These are some of the things that kind of go through a lawyer's mind. And what I'll tell you right now is like the fact that these two withdrew like so suddenly on the eve of trial, that somebody screwed up big time. Mm-hmm. You know, you don't see stuff like this like in the general practice of law. Like I've only withdrawn from about 5 cases that I can think of, like off the top of my head, and 2 of them were for benign reasons, like this. They've simply found another lawyer, like, fine, here's your file, you know, God bless. But like there were 3 I can't even talk about them really. Basically, I caught my client in a lie, like 3 times, and you're in a position where like you can either like continue on with the client's perjury, or I mean, the ethical thing is to withdraw, and there's an ethical rule in Texas where, get this, if you find out your client is lying, you can neither reveal it nor conceal it. Like, that's how much of a bind you're in, like when you find out your client is perjuring themselves. So the only thing you can really do is like stop working right now and get the heck out. You got to withdraw. So the fact that this happened so pell-mell like this tells me that somebody screwed up. It's either the client or the lawyers, and the evidence is suggesting the lawyers.
Yeah, I heard one rumor. I don't know how true it is, and it had something to do with the fact that apparently that the lawyers wanted to prove him innocent, and that maybe Richard Allen wanted a plea. I don't know how true that is, but if that were to be true, if there was a situation where an attorney sees an avenue where there's reasonable doubt, like for instance Elvis Fields, it was described that Abigail Williams had either horns or branches above her head, and he said that he put horns above her head because she was a troublemaker, and he had confessed to committing the crime to his sister. He sees that avenue open, right? Can a lawyer I don't know, what can a lawyer do in that moment if his attorney or his client wants to make a plea on it?
Mm-hmm. Well, I mean, if the client wants to make a plea, there's very little you can do. I mean, you got to do what your client tells you. On the last podcast you had me on, you said that like, the plea was like standing silent. Like, that's not something I would advise the client to do. But
Right.
If that's what they want to do, like, they're the boss. Like, it's not the other way around. The client's the boss and the lawyer's the servant. So if somebody comes forward with exculpatory evidence, it'd be my duty to interview them, figure out what they have, like what are they willing to testify to. Is there any kind of credibility issue I'm going to run into at trial? Like something that the prosecution will impeach them on. Mm-hmm. But as far as like doing like pleas, like you have to do what your client tells you to do. The client is the boss. Just like if settlement offers per se, like if your client wants to issue a settlement offer to the other side in a civil case, you basically have to stop what you're doing and present the settlement offer to the other side. Now, I'm not saying like you miss a deadline or something like that, but you have a duty to present the settlement offer to the other side within a reasonable time.
Gotcha. Thanks. That makes sense. Desiree says she loves the stream. She has a question for you. She says the judge ordered all discovery returned to the state. So what if it never resurfaces with new counsel?
I mean, that seems like a relatively quick fix. Like in most states, the prosecution has an open file, like the defense, if the defense requests it, the prosecution has to turn it over. Like, and I'll make this point in Texas, it's kind of crazy. Like, there's no reciprocal discovery in criminal cases in Texas. So like you kind of have an advantage as a defense lawyer in Texas, because basically you can be like, ask the prosecution to turn over their entire file and you don't have to give them jack. Like on the other side. So really? It kind of balances out though, because like criminal law, like your clients are usually not very bright, and like you end up with motions to revoke probation, like some kind of deal that with the prosecutor that your client screws up on. That's been my experience. But discovery, like the new defense counsel will be able to get whatever the prosecution has. I wouldn't be too concerned about that.
Makes sense. Well, yeah, I didn't think that would be was going to be an issue either.
See, I had a question about this one, like, because somebody asked it. If you're representing somebody and they can't afford to pay at that time, most of the time, y'all don't take payment till the end, right? Like, so They just get billed for it.
Not always. Like, I'm glad that this is being brought up here. Like, that's kind of a shadowy misconception. In Texas, you're not allowed to go on a contingency fee for family law cases or criminal law cases. And like, the rationale behind that is like the state doesn't want to place like some kind of like I don't know, general reward for winning. You know, like you just have to proceed on the case as it. So basically, you either get paid or you don't. And just because the client runs out of money, that doesn't necessarily mean you can get out. If they're not complying with the fee agreement, then like that would be grounds for withdrawal, but you'd have to set a hearing. But at the same time, you can't just sit on it. Like if you're waiting, and if you're on the eve of trial, the judge might not let you out and you might have to work for free. That being said, like this is a public defender's office as to what I understand. So they're not paying anything. This is funded by the state. So yeah, that's the fee situation.
Go ahead.
So I was wondering, when it comes down to the pictures being leaked, right, by one of the staff members of Richard Allen's lawyers, when you are given a client and you pick or you choose your staff that's going to help you, right? Right.
Yeah, I'm so glad you're bringing this up. Yeah.
What kind of, I guess, code of conduct, I guess you can say, like, are they allowed to talk about these cases after, even if they're not working for that certain firm?
No, really not. I mean, because typically what you do is you interview somebody just like any other job, but you make your employee sign a confidentiality agreement, you know, because like everything us lawyers do, it's privileged, attorney-client privilege. So if you got an employee that's running their mouth about other clients' cases, you know, that puts you in a bind because you know, they're breaching attorney-client privilege on your behalf, like respondeat superior. Again, the bar doesn't let you blame your staff. You know, the lawyer is ultimately at fault. And full disclosure, I don't have any employees for this very reason.
I have a. Oh, go ahead.
I scan my own documents. I answer my own telephone. I do my own meetings. I schedule my own appointments. I drive myself to court. Like I do everything in my firm. And it's because I'm so scared to death of like what an employee will do. Because, you know, us lawyers, like we're really too busy to micromanage employees. You know, like if I'm having to micromanage somebody, I'm not really practicing law. And I worked for a lawyer that did that. That was like, he became more of an office manager than a lawyer. And then I know another guy that he's got staff that like, I wouldn't be able to sleep at night if said people working for me. I'm not going to mention any names, obviously, but the answer to your question is like, yes, there are stringent confidentiality rules that apply to a lawyer's employee. But if those rules are breached, it's the lawyer's fault and not the, I mean, obviously the lawyer can sue the employee for breach of the agreement, you know, but where does that leave me in the interim? It leaves me like holding the bag and in trouble with the bar.
Yeah. I was going to ask, because I know like I work in the medical field and I have to abide by HIPAA. And if I break HIPAA, you know, it's either my job's on the line. You know, I either have to get, you know, the company gets fined, or you know, one of my licenses is you get put on probation. So it's a lot of stuff that is on you, not sharing that information. So
yeah, HIPAA is very similar. Yep. Doctor-patient privilege, you know, you go to a doctor's office, it's similar, you know.
Yeah. So I have a question for you. If you were the co-counsel that didn't do anything wrong, if you were part of a trial and your co-counsel had an employee that leaked some stuff, what would you do in that situation? Would you withdraw automatically, or how would you handle that?
Well, the general rule is that if you're placed in a position where your representation is going to be materially and adversely affected by like the screw up, like whatever caused the other lawyer to withdraw, then you really have an ethical duty to withdraw yourself. You know, like I've got a case right now, like I won't say where or who or what, but the lawyer on the other side really should consider withdrawing because like they're not doing their client any favors by continuing with the representation, because like it's possible that malpractice may have been committed, and like the lawyer is kind of trying to save their reputation, I suppose, but they're really digging a hole deeper for themselves. So if it were me, I would just withdraw like as soon as practicable.
Makes sense. And what would happen if obviously, if the judge says no, you can't. Are you surprised that the judge said yes? I mean, I felt like a lot of folks, like on Court TV and a lot of people on News Nation, they brought up, a lot of folks, and they said, this close to court, understanding, releasing Baldwin, because I think that was the one that was allegedly who had the employee. But to release both of them, there was supposedly rumors that one of them was going to get released, being the one that was directly involved, and that the surprise was that the other lawyer asked for withdrawal as well.
Mm-hmm.
Are you surprised, given how close to trial this is, and there's a Franks hearing supposed to be coming up, that the judge allowed it?
Yeah, I actually am surprised. I mean, when it's so close to trial, like it really becomes hard to get out of the case voluntarily. So I'm sure there must have been some meeting in chambers that nobody heard except the judge and the lawyers. And the judge is in a position where like, okay, like this is good cause to withdraw, so I'm going to let you out of the case. I mean, it's possible, like, the rumors that we mentioned earlier, like the judge was going to get rid of him anyway. But at the end of the day, we don't know. Like, I remember at the hearing, she said, like, oh, it's a surprise to everyone. And the thing is, we don't know what the surprise was. Like, was the surprise negligence on part of one lawyer or both lawyers, or the fact that both of them just wanted to get out of the case? And apparently they gave Her Honor a great reason to get out, because typically you can't get out that early. I mean, like, yeah, like a long jury trial, murder trial like that. Yeah, it would be really hard to get out at that late stage.
You got a question, Blue?
Yeah. Now, I had a quick question that I thought of right now. What do you think do you think the reasoning that they moved further in this action is because of what we do online? Not per se you, but like say us talk about the images that were released, and there was tons of creators that brought them out, talked about them, and that set like a little bit of the internet on fire for a little bit.
Mm-hmm.
I think that might have been one of the causes for them to, like, I think in normal cases we don't hear about this kind of stuff unless the newspaper catches on to it,
Mm-hmm.
or the reporters, because in most cases there's not this big.
Yeah, I mean, allegedly what was leaked was like graphic photos of the crime scene, like including the bodies.
Yeah.
So I guess like the rationale, assuming that what we think is true, I have an employee that leaks these crime scene photos out. They're very disturbing and they're very gut wrenching, like it strikes down to the heart of the community. Like, have I suddenly placed my client in a worse position by exposing the general public, like, to the crime scene photos? All of a sudden, like, the potential pool of jurors I'm going to have to pick from have all seen these grisly photos. So, like, yeah, I mean, that is good cause for withdrawal. Like, you fundamentally screwed up your client's case and put him in a worse position than when you found him. And that compromises your ability to represent him. So they probably, if that's true, they probably had an ethical duty to withdraw, like under their bar rules.
If you were the new counsel added or the new attorney for Richard Allen, would you feel a little bit, I guess, maybe handcuffed to a certain narrative because this narrative is out there in the public that this was Odinistic, that, you know, law enforcement, specifically Liggett, arrested Richard Allen because there was an election coming up and he needed to, it would look better for his, for that election on his behalf. Do you think that the new counsel would be, I guess, kind of have to follow the same avenue, so to speak?
Not necessarily. Like, I mean, as a lawyer, I've taken on cases that somebody else handled initially. Like, they fire their lawyer and they hire me, and I just start fresh. Like I pick up the file, I see what was done, and if that looks like the way to go, then by all means, that's the way I'm going to go. But there have been some lawyers where I totally go in a different direction. I had this probate case where this other guy was attacking an inventory, like an inventory of an estate, and I didn't even go there. Like, I just went to settle it based on a real property theory, like a trespass to try title and adverse possession. So I'm saying that like in the civil sphere, but like as a lawyer, like you kind of start fresh, and like whatever the facts and circumstances dictate that's best for your client, that's where you go. And a lot of times you have to make a judgment call. It's a personal judgment call on, like, this is the theory of the case that the last guy had. Like, is this best for my client? Is it best that I continue down this rabbit hole? And if that's the answer, then that's the answer. But it's really something you have to determine on a case-by-case basis.
I think I might be able to answer this one. In my theory, is the reason why he's not in a jail and why he's in a prison is because they have more amenities at a prison. They don't have, I think, psychologists and the mental health departments that they do in prisons and jails. And it's for his safety, too. They have more solitary confinements, and I think that's where they're keeping them. They're keeping them out of gym pop. That's my theory.
Zach, if you were, Richard Allen's attorney, would you prefer to him being in a prison versus a county jail? Is there a difference? What do you think about that?
Yeah, I mean, with what he's faced with, that like a child killer, like alleged child killer, like you're probably going to want to put him in some kind of administrative segregation, like out of gen pop, like Big Blue is saying. Yeah, county jail, like he's going to be a prime target in there, like he won't make it to trial in county.
Gotcha. Huh. So this angle is just to throw basically mud on the wall and see if it sticks. Like,
yeah,
hey,
and like,
go ahead.
That I think I said that very same thing on the last show I was on. You throw everything against the wall and see what sticks,
Yeah.
That's litigation.
And it's stuck to us. Yeah, we say it sometimes. Like, yeah, Zach said that.
Jaime, you have some?
What's up?
Do you have a question?
I did, and I totally forgot, man, when I started laughing. I'll think about it right now, man. My bad.
No problem. So, with this all being said, you're thinking that this is probably going to push everything about a year or so down the line. Man, that sucks. That sucks for the client. That sucks for the victims. That sucks for everybody across the board.
Taxpayers.
Yeah. Do you think that something is going to happen to these lawyers from the bar?
I don't know for sure. Probably not. Like, because the ethical thing to do is withdraw. So, like, at least in that regard, they did the right thing. If they screwed up and continued working on the case and the client was prejudiced because of it, then they'd be in trouble with the bar. But it sounds to me like withdrawal was the right thing to do, considering it was so close to trial and so sudden. So, like, sometimes that's what you have to do,
Do you think there'll be some sort of do you think this could lead up to some sort of appeal or right for appeal after the case if he's found to be guilty?
Not necessarily, because see, your right to appeal, like generally that only happens during trial. Now, I guess there could be some kind of error in discovery or venue or something like that that you could appeal later. But basically, during the trial, like if the prosecution does something that's illegal or something that's not permitted under the rules, you have to object. Now, just because they did something against the rules, that doesn't necessarily mean it's appealable. If you don't object, you don't preserve error for appeal. So I doubt that this is going to give anything like any grounds for appeal later. And that's the whole reason we're postponing it, to like make sure that we get it right. Because if we try to go now, then yeah, of course we're going to get it wrong, because the new lawyer is not going to have enough time to go through the file, and screw ups are going to happen. Even more screw ups that have already happened are going to happen.
Yeah. I have a pot. This has a question. Says, how do you proceed when a judge ignores your motions?
You object on the record. So like, you could do like a motion to reconsider a motion. Like a motion to reconsider your previous motion. If the judge ignores it at a hearing, you make an objection, because there's a court reporter typing everything out. Like that's what they call on the record. Like it has to be on the record. If it's not on the record, you're SOL. But as far as the judge ignoring motions, a lot of this stuff is discretionary. So if the judge is within their discretion, then he or she has a right to ignore the motion.
Could the judge face an ethical violation for removing the defendant's counsel against his wishes? Can Allen appeal now that he has violated his right to counsel? And I'll answer this. Can Allen request that the attorney stay?
Yeah, the client could, but if the lawyer wants to withdraw, like there's basically little stopping them from withdrawing, like even if it's so close to trial. I mean, obviously they gave them a good reason. They gave the judge a good reason, the court. That brings up an interesting question about like what Sixth Amendment right to counsel. Like, yeah, like the judge may not have been able to, get rid of these defense attorneys if the client or the defendant rather like desired their presence. Like no choice of counsel. Like I want my that's who I want to be my lawyer. But the problem with that is that these lawyers withdrew voluntarily. One made an oral motion on the record, and the other one made a written motion and filed it. So like you're allowed to cut the cord if you're a lawyer, the attorney-client relationship ends. Like if it's not in the best interest of the lawyer or the client to continue with the representation, then that's it. Sayonara.
Yeah. What was that, Blue? You were going to say something?
I was going to say that I don't think the judge could have any repercussions for that, because the judge, like you said, the lawyers did withdraw.
Yeah. Like maybe if like it was by force, like the client wanted to keep the lawyers and the judge said, no, I want them off the case. Like, yeah, that's probably some kind of constitutional issue, but they voluntarily withdrew. So
interesting. What's up, Hannah?
I was going to ask, I know a lot of these cases, especially this high profile in small towns or small cities, they usually change venues, right? In this case, knowing that the previous lawyers had the angle of the Odinist angle, and they were saying that some of the corrections officers were involved in this too, wouldn't that be a real good reason for them to change the venue?
Yeah, probably. I mean, I would be thinking of change of venue regardless, just by the fact that evidence was leaked. Like the defense is in a position where they may have to. Like they may not be able to get a fair trial considering how badly they bungled this whole thing up. But, the fact that we haven't, I don't know how pervasive this Odinistic religion is in this community. Like apparently it's like police officers are a part of this with the patches and whatnot. But I don't think that fact just by itself would be enough to consider a motion to transfer venue. Like the fact that the potential jury pool, the potential is so tainted. Like, you know, that's the reason you need to start thinking about transferring venue.
Yeah. Yeah, that's what I was thinking. I was surprised that they even kept it there because, you know, this case has been ongoing for a while. There's been a lot of speculation, especially within that community about who might be involved and who might not be involved, you know, down to even speculating against some of the family members and things of that nature. But yeah, when it comes to the law enforcement aspect, I know that they had certain corrections officers that had the Odin, you know, in Odin We Trust patches that were visible and that they had also had acknowledged on their testimony. You know, with that said, like, you know, one of the biggest things or stories is that I guess rumor conspiracy that is going on right now is that it was all an effort to get these attorneys off. That I guess that the person who leaked the images, I guess, was some sort of double agent or something. I don't know, but that that basically the goal was to get these lawyers off this case so that they don't, you know, the next one can, you know, maybe is a little bit more under the judge's control or whatever, and they won't go under this angle because I guess they don't want the law enforcement to look bad.
Mm-hmm.
I doubt you think that any of that is true, but what are your thoughts on that conspiracy?
Well, I don't follow that at all. Like, I mean, because see, the new council, number one, they're going to have a ton of time, you know, because there's going to be a huge reset, and there's probably going to be resets on top of resets. You know, like we're looking at least a year, and that's conservative. Like, and then, like we were talking about earlier, the new council is going to look at everything the defense had and everything the prosecution has. So it's like they're going to see whatever the first lawyer saw. So it's like, I guess if this conspiracy is true, they're going to have to get rid of the new lawyer too, and we're going to end up in this loop, I guess, of withdrawing attorneys that the Odinistic cult is trying to get rid of to keep this poor man in jail, assuming he's innocent.
Right. What's up, man?
What happened to the person who leaked these pictures?
The staff member?
Now, I know they're investigating two of them, and one person took his own life.
Interesting. I didn't know that.
When it comes down to the Odinism angle, right? If your client was Mr. Allen, right, and he was being harassed or assaulted or whatnot, and his concerns were also about his family, what can you do as a lawyer to help prevent or protect your client's family members?
Mm-hmm. Well, I mean, like, the first thing you'd have to do is establish that the threats are credible, because I mean, what you could do is like have some kind of motion to have defendant's family in protective custody or something like that. But the judge ain't going to do that just based on rumors. Like, they have to have a damn good reason. So as long as you can articulate a reason like that, you can get some kind of order from the judge to protect defendant's family. But it's probably a long shot. Like, I don't see that happening in this case, like assuming what I've seen and read, and it wouldn't be common, like even in circumstances that are worse than this case.
Good question. That was a good question. What about you, Big Blue? You got any other questions?
No, I have a question, but it's not pertaining to this case. It's just so the other day we were talking over a case of the Long Island killer, the Go-Go Beach killer.
Mm-hmm.
And some new, I guess, victims are being linked to him. And there was a big old thing, I think it was on one of the crime TV or something, where they said that they're getting this information from past, I guess they were swingers, right? And they're getting them from past people they've met
Mm-hmm.
that can eyewitness maybe one of the females were seen at the same party as the suspect. But right away, all the lawyers on the stand they were like, nope, they're gonna throw it out. It's no good because it's not coming from the prosecution. It's coming from the victims, like family lawyers.
Mm-hmm.
So is that something that would happen right away? Is like they get thrown out right out the window if it's not coming from any of the two defense lawyer or the prosecution lawyers?
Well, I mean, I'm going to give a typical answer. It depends. A typical lawyer answer, like that sounds like, you know, you might have an objection to hearsay, like a hearsay objection, but at the same time, you know, if we're talking about discovery, like before trial, there's very little information that's not discoverable. So it's like, just because a statement's hearsay, you can get to it in discovery, you know, like, so, excuse me. The prosecution does discovery. They find a hearsay statement. They can, you know, it's in their file. And the same thing with the defense. They find a statement from prosecution that's hearsay. It's in their file. When you get to trial, obviously, like, you know, you make an objection on the record to hearsay. But another thing that is often done is a motion in limine. Like if you got something that's like unfairly prejudicial to your client, like, I don't know, like let's take this guy, for instance, like the guy we're talking about. Say hypothetically, he had a charge for animal abuse, like when he was a child, like, you know, some kind of juvenile thing, you know, like, does that cast an unfair taint on him? Like the fact that he killed a dog when he was a kid, does that automatically mean he killed these two teenage girls? I don't know. So it's possible that the defense can do like a motion in limine to keep like certain specific instances of conduct out, like keep it out of the trial, like be that the judge or the jury. So I don't know in your case, Big Blue, about like, I don't know the facts, but
Yeah. I think these were like 20 years ago. They were a long time ago. So I think they right away they were saying, no, these things they're gonna get thrown out. But
I mean, if it was that long ago, like, you know, there's you know, memory issue. Like, is this witness credible? Like they're testifying about something that happened 20 years ago. So I mean, yeah, I think both sides would probably want to keep that out. I mean, it depends on what it is, you know.
Yeah.
Man, I had a question and I just lost it. Hold on, let me get it back. Okay, I got it. What are your opinions from a defense attorney's standpoint on social media? Like right now, for instance, in many cases, like you have, like, for instance, in the Bryan Kohberger case, you have two sides of the aisle in that case. You have a lot of people who think he's guilty. You have a lot of people who think he's innocent. You know, from a defense attorney's standpoint, how would you feel about, you know, the case being talked about on social media, on YouTube, on podcasts, things like that?
Personally, I think in that context, I think social media is a scourge. Like, I hate social media in that regard because, like, everybody's talking about it and it's so easy to talk about it, you know, like, now, full disclosure, I've actually sat on a jury before. Like it was right after I passed the bar exam. I didn't know I passed it yet, but I got called to jury duty of all things. And just for your listeners, the way you get selected for jury duty is keeping your mouth shut. Like I didn't say anything. I didn't say that I've been to law school or anything like that. They didn't ask me, of course, but I didn't volunteer it. So I ended up getting selected, and it's actually pretty strict what they make you do. You know, like you're not allowed to talk about the case like with your peers at lunch or anything. You're not allowed to look up the case. You're not allowed to go to the scene. You're not allowed to research the parties. Like you're very constricted with what the judge says you can do. And how closely those rules are followed, that's another matter. But like social media is such a scourge for getting a fair trial because, you know, it's everywhere. You know, like everybody's talking about it. Like even like this podcast right here, if I was the defense attorney, I would be upset that this podcast is taking place, you know, because it's like somebody is watching this and there's probably somebody in that town, and I'm going to have to put this genie back in the bottle, you know, if they say something that's like cast my client in a negative light, you know. So as a defense attorney, I hate social media. It's terrible. Like everybody should get off of social media.
That's good to know. That's good to know. I will object and say, everybody, I would like you to stay on social media.
Yeah, like and subscribe, please.
There we go.
There it is. There it is. Yeah, because that was one of the things that I'd been wondering. You know, I know that there's obviously, you know, if you came across a channel that was pro your defendant, you know, you're gonna, you know, that's gonna be okay in your opinion. Would you take anything that they found like on social media with any grain of salt? Like if you, for instance, came across a podcast and I guess like here recently, we were one of these guys, Pat Westfall. He was one of the guys that the defense was accusing to have possibly been involved. He came out on another podcast, did an interview. Would you be interested in that interview as Richard Allen's attorney? Could you use any of that evidence or anything he says in that as evidence?
Yeah, possibly. I mean, if there's something that he says in the interview that wasn't like relayed like to the public or like you know, obviously you're going to have to like double check stuff and like take everything with a grain of salt. But, you know, if a man's life is on the line, then you do whatever you have to try to get your client off, you know, like you try to like get them the best possible result that you can get under the circumstances.
Jaime, what's up?
I was going to put this up because Angel actually beat me to it. I was about to ask this question. If you're for or against cameras in the courtroom.
I don't know. I don't really have an opinion on it. Like, I mean, the public has a right to know. Like, there's a statute or a public policy that like courts are open to the public. You know, it's a governmental function, and you know we're allowed to be tried by juries of our peers. You know, and we're allowed to see how our government operates, like open government. So I think cameras in the courtroom are good, but when you factor that with social media, you know, that's another story. But really, like the camera, the courts should be open to the public, you know, like regardless. And that's why a lot of courts are on Zoom now. You know, Zoom was kind of like a product of the COVID era. You know, like you never had these Zoom hearings before COVID. And now it's opened up the courthouse, be wherever that is, like to the public. So, yeah, cameras are, yeah, I think they're necessary. Like I have no issue with cameras in the courtroom.
Do you think that a camera focused in on a defendant's crotch area because his fly is down makes your defendant look more guilty?
Yeah, well, there's an argument to be made that like they filmed a certain way. So like I don't know if there's anything you can do about that as a lawyer. Like again, maybe a motion in limine, but even that's kind of a stretch. But it is what it is, you know. I mean, you know, the camera guy's likely going to say it was an accident, you know, like when they're pushed to it, but
yeah,
what can you do, you know?
Yeah, there was a meme going around, and I think it was probably a zoomed in, cropped out picture, but somebody had their fly down and it was made fun of. And I think that it was actually brought up in court. The defendant's attorney brought it up and showed the picture as evidence that they're making his attorney, or her client, look bad because of this this photo of his fly down. And I mean, I didn't think that it was I don't know if you can control what people are saying, because it wasn't even a publication. It was just some random person on Twitter. Yeah,
so I don't think you can. Like, I would be hard pressed to know. And you know, a lot of times you have a client that like asks for unreasonable stuff. You know, like, I can't believe they did this. What do you mean? Like, look, I mean, we had the hearing. Like, what do you want me to do? You know, I mean.
So do you think that was discovered by the client and not the attorney? This stuff on Twitter?
Judging by what I'm hearing from him, from the defendant, I doubt it. Like, he sounds like he's out of it. Like, and like, apparently he got interviewed by 2 psychiatrists that said he was okay, like he was competent to stand trial, I guess. But and then, you know, after this confession, when he has this mental breakdown, allegedly he goes back to normal. So I don't know.
He's talking about.
Yeah, I'm talking about the fly situation.
Mm-hmm.
Yeah, the fly thing was on Bryan Kohberger, the guy in Idaho. It was the last time that we were here.
I'm sorry.
Yeah, no problem. I didn't explain it correctly. Bryan Kohberger walked into the courtroom, and there was a picture taken of him, and there was his fly was down. And I don't even remember the statement. Blue probably does because he was laughing at it the hardest. And but it said something about his fly, you know, not being up or whatever. And that picture ended up in court documents. Now, my question is, do you think that's something that was found by the attorney going through Twitter?
I think the other main reason why it got brought up was because when he sat down, they were focusing on him, but because where they made the camera people sit, you had a good view at her laptop when it was open. And supposedly they're not allowed to.
No, well, that was. I zoomed in on that. Yeah, I zoomed in on that, and what you saw were the camera angles of everybody else.
I know, but that and they can see like her documents on the table, and you're not supposed to be able to see those too.
Right. But they specifically brought up the fly thing, and that was when he was walking in. There was nothing else around. So do you think that was found by his attorney, or do you think maybe he has some sort of privilege online and he discovered that?
I don't know for sure. Like, Kohberger seems like he's out of it too. Like I said that at the last show I was on, but it's possible. Like the lawyer found it on social media. I mean, if it ended up in court documents, then that's good reason to complain about it. Like if suddenly the trier of fact is going to be seeing that, but I mean, really, does that prove guilt or innocence that we zoomed in on the guy's crotch? I mean, like, it seems like it's neither here nor there to me, you know, just an accident probably.
Yeah, I didn't see it as more than, you know, somebody just kind of making fun of the situation. I didn't see it as being something that pointed towards guilt or innocent.
If it's something intentional, I will say it's in poor taste, obviously, but what more can we say about that?
Yeah, exactly. Jaime?
I was going to say, when it comes down to that aspect, you know, Danny was saying about, you know, zooming in on the guy with the zipper down and whatnot. Isn't it the same? Like they're trying to paint this picture on the certain person, right? But isn't it the same thing as when you get a client and you get them all nice, clean cut, and they're dressed nicely to make them seem more, I guess, confident and believable and stuff.
Yeah, you know, I'm glad you brought this up, Jaime. Like, you wouldn't believe how many times, like, I'll tell my client to clean themselves up, you know, shave, you know, put on a collared shirt, put on a tie, like, you know, like look presentable, and they show up, you know, unshaven with a t-shirt. You know, some of them have shorts, and like, did you listen to a word I said? You know, like, and thankfully for our community, most judges these days don't really like bat an eye about it. Like, and because I've been flat out embarrassed by some of my clients showing up despite my advice otherwise on their appearance. But yes, there are concerns that you should clean yourself up when you're going to court, you know.
So Afton has a question. She says, can that affect the client's courtroom demeanor, make them look more anxious? You know, the way the camera's focusing in on somebody. And would that affect the case? Because here's the thing. like the jury's not supposed to be watching courtroom or video of this. So I don't understand how a camera, even if it's focusing in on Kohberger, is going to affect the decision from the jury.
Mm-hmm. Well, another thing you have to consider is like, let's put ourselves in the defendant's shoes. Okay. You're totally innocent. Okay. But you're accused of this crime where you could be going away for at least 20 years, maybe the rest of your life. Are you going to look calm? Because I sure wouldn't.
Right.
I would be scared to death. You know, I would probably look guilty, even though I wasn't, you know, like, so I don't think like any of this observations of how the defendant looked, like you have to take them with a grain of salt because, you know, you're not at your best when you're under trial, like especially for crime or charges that serious. So you have to consider that, you know, like there's a ton of stuff going through that defendant's head, you know, like what's going to happen to me? Like, what's going to happen to my family if I go away? Like, what's going to happen to me if I go away? Am I going to survive this ordeal? Am I going to survive prison? Is there any way I can get out? Is there any way I can get a deal? You know, like something. All the 5 stages of grief, you know, every client goes through when they're under trial.
What's up, Hein?
When it comes to Richard Allen, Richard Allen, he lost a lot of weight and he doesn't look like when he went in, right, into jail or prison. Is that how bad do you think it was going to affect the way the jury thinks, looking at him in such a fragile state?
Probably not very much, honestly. The reason I say that is because, like, it's kind of natural for people to lose weight, like when they're in custody, like for a long period of time. And that may or may not have anything to do with any like abuse from the prison guards or the jailers. Like that's just natural. Like you are going to lose weight when you're under that much stress and in custody. Like I'll bring up an example here locally. Like we have this I'm trying to think of a more sophisticated word than big shot, like this high-tone lawyer by the name of Chris Pettit that's going to be facing some criminal charges. Like allegedly he swindled a bunch of his clients out of some money, and he's been in custody for some time. And if you look at him, he's clearly lost weight. And what is the reason for that? Like, is he being abused in the prison, or is he just under a lot of stress and like really considering his life choices? You know, like I don't think it's going to like make too much of a difference how the defendant looks in this specific case, because it's natural for them to not look as good as them being a civilian out in the open. You know, if they're in custody, they have a public defender, you know, they're going to be in a rough shape. You know, there's just no other way around it.
I mean, he lost a lot of weight though, right?
Oh yeah, he did. Yeah, he lost a lot, and I was trying to find a picture. He looked pretty rough. He had dirty clothes on and things like that.
Allegedly, isn't he like eating his defense attorney's paperwork? Like I read something that like he's like wetting it and like literally eating it or something like that. I mean,
peppermint it.
Yeah. And like they had to like put him in some kind of like they had to put him in a smaller cell because he was talking about committing suicide or something like that.
Yeah, he's been in rough shape, and you know, Mythbusters busted that, you know, paper and cardboard boxes have very little nutritional value, so that would mean him lose a lot of weight. I
mean, you don't have access to McDonald's or Burger King. You know, you don't have access to beer. I mean, you got access to hooch, but not beer. Beer is more fattening.
They're just keeping you alive in that jail. Like you ain't. There's no happiness going on in there. I can guarantee you that.
Yeah, you stare at the wall all day.
Yeah.
You know, when going back to like the attire, what they're wearing and whatnot. I said whatnot. Everybody drink. When I saw Kohberger, let's go back to Kohberger, right? When I saw Kohberger in the jumpsuit, right, the prison's jumpsuit, and then when I saw him dressed up I'm gonna say he looked more guilty in that jumpsuit, right?
Oh yeah, yeah,
I guess-
100%.
Yeah, then you see him dressed up, and you don't see that. I don't know. It just throws you off a little bit, where you're like, that might not be all true.
So I got a question for you, Zach. You said that it's not uncommon for clients to lose weight and stuff like that, especially when they're put in a situation like this. What about a client that looks healthier? What are your thoughts there when the client goes to prison or jail, is awaiting trial, and face isn't as sunk in after a while? Looks like maybe they gained a couple of pounds. What do you think? Why would that be such a different reaction?
I don't even know if it would be a different reaction. Like, it'd probably be like a net zero reaction. But there is an argument that, like, I don't know, it could go either way, because it's like, assuming you're guilty, like, how much stress are you under? Like, because you're going to suffer some kind of physical change under stress. But, or what is the opposite of that? Are you a psychopath? Like, do you literally have no reaction to what's going on? It's like, this murder trial, this ain't nothing. Like, yeah, of course I killed those people. I mean, who cares? Like, so I don't think you can really gain much from a defendant's appearance. Like, there's not much to glean, because it could be so many, like, a variety of factors,
Yeah, one of the thoughts I had is maybe perhaps somebody going to prison on, addicted to something, and then don't have access to said addiction, so they end up gaining or looking healthier.
Yeah,
that was my first initial thought. But stress also would cause that, and
I mean, it happens to people all the time that go in, they get charged with meth. You know what I mean? You see them go in, they have the blisters everywhere. They're a lot more skinnier. They come back out quick, bigger, and have more healthier skin and stuff.
Yeah. So in that specific context, it actually helps them, because like if they don't look like a drug addict, like judges and juries, like they're plagued with the same kind of prejudices that the rest of us are. So I mean, if walks like a duck, quacks like a duck, it's probably a duck. So if you got somebody that was a drug addict, they got into jail, and you're coming up for some kind of rehearing, they don't look like a drug addict anymore. That specific instance, that might work in the client's favor, or in the defendant's favor, rather.
Interesting.
Mm-hmm.
I have one last question about the jury. So probably in many of these cases that we cover, these high profile cases, the jury is typically sequestered. In those situations, do they not have access to their phones? Like, what happens to a juror when they're sequestered, and what are they watched? Are they monitored? Things like that.
Mm-hmm. Yeah, usually, yeah. Like, it depends on how strict the judge's order is, but for a high-profile case like this, like, yeah, they're going to be they could be sequestered for months away from their family, and not allowed to talk with each other about the case. Like, they're only allowed to, that small window of time that you're sitting and hearing this testimony, that's when you're allowed to write your little notes and start thinking about the case. And then when you go home for the night, like at the hotel, like, that's when you turn your brain off, allegedly. You don't look at anything. You don't crack open your computer. You don't crack open your smartphone. It's rough. Like, I don't think I wouldn't want to be on a jury like that, like a high profile case, because, you're stuck. You are stuck until the case is over. Yeah.
Oh, yeah. Do you think that puts on some sort of strain on the jury to choose one way or another quicker, or anything like that?
Yes, possibly, but you have that anywhere. Like, my boss / landlord was retelling a story to me where, like, apparently he was trying a jury case and he had the whole thing won. Like, but there was one juror that said, no, I think the guy did it. And he made them stay there until they changed their minds. Like they allegedly they had the case won, but they that one juror screwed the whole case up for my landlord. So you know, and there's possible you can go like the juror misconduct, like that might be grounds for a new trial or something like that. But you have to understand, like, these are people, these are human beings like you and me, and we're all subject to the same weaknesses as everybody else, you know?
Yeah. So Angel has a question, and it's a good one. I'm glad she brought it up. So in the Bryan Kohberger case, it's been alleged that 2 of the grand jurors have come out and spoken about what they the information that they have heard while in grand jury. Supposedly, that information, according to a couple of articles, that grand juror information made it to the victims' families, and in which at one point, according to an article, one of the victims' families was going to attempt to contact one of the witnesses. Supposedly, the prosecution got involved, told the families not to, that this person came in under a tip, so they can't be bothered or disclosed. What can happen if a juror speaks out like that and talks about evidence that they heard while in grand jury before a trial actually starts?
Yeah, like that's never happened to me personally, but the juror could be subject to sanctions by the court, you know, like violating the court's order. Like, so we're looking at money or potential jail time, you know, for you're in criminal contempt of court by violating the court's order. So, you know, grand juries are pretty strict. So, whatever's going to happen is not good, you know, like that's juror misconduct on a whole nother level.
Now, the defendant's attorneys are already trying to get that grand jury indictment thrown out. They're claiming that a couple of things, that, for instance, I guess some of the evidence that they used against Bryan Kohberger in the Kohberger case was evidence that's not going to be admissible in court. One of the things is, I guess, the IgG workup that's not supposed to be used against Bryan Kohberger, and I guess they're assuming that they use that in grand jury. Mm-hmm. And then you have this grand juror, or 2 grand jurors, apparently come out and start speaking about what they've heard. Is it possible to get that indictment thrown out based on this, and what would happen if it does?
Well, I mean, it kind of depends on what else was brought up at the grand jury. Like, see, grand juries are kind of a unique animal, you know, like nobody's allowed to be in there except the defendant and, you know, the judge and the grand jury, and the defense attorney can't even be in there. Like, and the only evidence that the jury hears is all damning testimony, like testimony that points towards the guilt of the defendant. Now, assuming that's all they had in the Kohberger case, then yeah, obviously throw the indictment out and get the case dismissed. But I'm sure they probably had more than that, which is why the case hasn't been dismissed. Like, you know, the same rules, it doesn't really apply in a grand jury case. Like, you know, the best you can do is, like, if you get the indictment thrown out, you know, like, then you can get the case dismissed. But like, that has to be only that, like, there was probably other evidence that suggested the guilt of Kohberger.
So if that were to happen, they get the grand jury thrown out. That doesn't mean they can't recharge Kohberger. Is that correct?
Well, yeah, they could recharge. Yeah. So, like, there is a thing in called double jeopardy under the Constitution, where if you're tried under a certain case, say, you know, like, you can't have a double trial for the same allegation or the same conduct, you know. That it depends on, like, when jeopardy attaches, you know, like, if you're facing state crimes, you know, you can be tried federally for the same one because dual sovereignty. Same thing with, like, civil cases, you know, like, if you're under trial for murder, you get acquitted, you know, you can still be sued for wrongful death, you know, like, we're talking about virtually the same facts, you know, like, but Yeah, it would permit the prosecution a chance to refile, if I'm not mistaken. Like, and I don't think I am mistaken.
Yeah, I just felt that I was like, it's going to be like, even if it were to happen, it just would recharge him and do another grand jury. I think that what the goal is for the defense is to acquire a preliminary hearing and to bring, I guess, more doubt and, I guess to have their defense there. Like you mentioned, in a grand jury, the defense isn't there. So in a preliminary hearing, the defense is there, and they can kind of, talk about the evidence and from their standpoint. But yeah, I mean, I think they should just do the preliminary hearing, regardless. They were going to do that anyways. If the guy's guilty, just do it. Hyman, what's your question?
Well, I was going to go back to Richard Allen. In Richard Allen's case, I was going to ask, when Richard Allen gets his new lawyers and they go through the trial, and at the end of the trial doesn't come back in his favor, can he still claim mistrial for the leaked pictures and all that stuff that happened when he wasn't in part of the
if it came out in his favor?
No, not in his favor.
Okay. The defense would have to prove that the jury saw something that they didn't. So the burden would be on the defense, to do that. Mm-hmm. So the short answer to your question is yes, but can we prove it?
Well, I mean, there is pictures out there, but I don't know if I don't know how far those pictures have gone.
Yeah, and see, that's the thing. Like, the fact that pictures are out there, is that enough? Is that enough to say that we didn't have a fair trial?
Yeah.
Like, I would be inclined to say no. Because we have a court system that accounts for this, allegedly. Like, it's not perfect, obviously, because we have mistrials all the time. But, that's the same reason we have jury sequestration, to try to prevent this kind of thing from happening so that we don't have to waste years of the defendant's life, years of the victim's family's lives, and taxpayer money defending a potentially innocent man,
Yeah.
Yeah.
Let's see. I'm going to look through here, see if we have any questions from the live chat real quick. Big Blue, what do you got?
No, you answered it all. A lot of good questions for me. I don't have anything right now.
Well, Zach, I want to thank you for coming on. We're almost to the 2-hour mark. Do you have any questions for us or anything?
One comment I'd like to make. Like, I noticed that there was a comment that came in like early on about the confession.
Yeah.
Like, that's going to be very hard for the defense to surmount, for them to overcome. Okay. Like, because they do tell you when you're in custody, like, anything that you say on the telephone can be used against you. Like, it's recorded, everything is recorded. Like, and you called your wife and daughter, is it right?
Mother. Wife and mother.
Yeah, your wife and mother. That's it. You called your wife and mother to confess. I'm not saying that like he's guilty just based on that, but that's going to be really tough, like, because that's admissible. That's an admissible confession. And if I were the defense attorney, I'd be thinking about some kind of deal if the prosecution was willing to offer it. And between you, me, and your listeners, that's kind of 90% of criminal law practice. Like, you get postponements, get the case delayed as long as you can, because the longer the case goes on, like, the worse the prosecution's case may get, like, witnesses' memories fade, like, you got an officer that doesn't work on the force anymore, so you can't get them to testify. You don't know where they are. And then, at the end of the day, you end up just doing deals, you don't try a lot of cases in criminal law. Like, you typically just plea them out. So, assuming the Richard Allen isn't losing his mind, you know, like I would be trying to consult him on some kind of deal. Like we need to do some kind of plea agreement with the prosecution. Otherwise, you're going away for a long time. Is there the death penalty in this state?
In Indiana, yeah.
Okay, yeah. You know, you could be facing execution. Who knows? Like, and you know, the sentencing hearing is something else. Like, you know, you have the trial, that's the guilt or innocence phase. Then you have the sentencing phase, which is a whole nother hearing. So the general public just needs to strap themselves in, because it's going to take a while before we know if Richard Allen is guilty, and if he is, what's going to happen to him.
Good deal. Jaime, you had a question?
Not a question. I was just gonna say thank you and your majestic mustache for being on the
show. Thank you. I work hard at it.
Yeah, thank you.
If the confession didn't give out any specifics, and you have, you know, him eating his paperwork, do you think that's enough to have it thrown out or not used against him?
Yeah, possibly, but they have to make the argument. Like they have to do some kind of competency hearing. And allegedly we have 2 court-ordered psychiatrists saying the guy's A-OK. So if the defense, if they want to play this card, they need to do it now. You know, like don't wait, because like we're already close to trial, you know, or plead the insanity defense, which that's a whole nother can of worms in and of itself.
100%. Do you think that well, they've already kind of said that the reason behind him making those confessions was because under threat or duress. Can they change that? I mean, obviously, because they're having a new attorney, they can probably change that narrative, right?
Yeah, they could.
All right, cool.
The mere fact that he's eating paper mache is pretty good evidence of insanity, assuming he's not doing it on purpose. He's not faking it. And I have seen cases where some defendants do that. Like they all of a sudden, no history of mental illness, and they go crazy as soon as they're facing some kind of criminal charge.
Yeah. I was watching this thing. It's completely unrelated, but it was about some sort of exorcism. And this guy said that, so it was about this family that believed that one of them was, I guess, possessed by a demon. And then later on, one of his family members goes and shoots and kills somebody else and claims that he had that demon travel to him and that he was possessed, and that's why he committed it. But holy crap, where was I going with that? Go back up a couple of...
The devil made me do it.
Right.
Quite literally the oldest excuse in the book.
Yeah. Geez, there was a reason I was saying that, and I can't remember what it was. It completely... I was
I wasn't paying attention.
Blue, I know you weren't.
But there's also been case. I remember hearing about a case where this man ended up killing. I'm not sure it was the wife, but apparently he was asleep through the whole thing.
Sleepwalking.
And supposedly he won. I'm not sure if that's true or not.
Yeah, I did hear something about that. Like, I can't remember off the top of my head, but I do remember something like that.
That was like the first case ever of that. I don't know if there's ever been another one like that, but I remember hearing about it, and I'm like, wow, that's crazy. I think they had him under observation for so many days or something like that.
Mm-hmm.
That's crazy.
I remember where I was going with that. So apparently, when the kid was having his demonic episodes, you know, they were recording it, and actually Ed and Lorraine Warren were some of the folks that were investigating this, and they had an older brother who thought it was hogwash. He's like, this is bull crap, it's not real. And he came out with a story where he was like, yeah, you know, the devil was saying all these bad things to my mom until my dad got in there and said, I'm tired of this shit, and slapped him. And the devil listened to my dad. And so, you know, that just kind of told me that, yeah, he's not possessed, Richard Allen. If he's, you know, they're going in there and they're saying, hey, you know, he's A-OK, you know, 2 different psychologists, and then he starts going crazy during this time. Kind of a similar situation, sort of. But yeah, I want to thank you again, Zach. Thank you so much. You want to let everybody know, what type of law you're practicing now in case they need your services and where they can find you?
Yes, unfortunately, well, fortunately or unfortunately, I don't know, take that however you want. I don't practice criminal law too much anymore. Like I've only got 2 cases that I'm working on in that field, but I primarily practice family law, probate law, real estate, and business. So I feel like I really shine in family law and probate litigation. So if you have a nasty divorce or a will contest, you're not getting your fair share under dad's will, or you have a guardianship, like a guardianship of an elderly adult, they're being taken advantage of, like, give me a call. That's where I love those cases. I love getting in the boxing ring and fighting.
I might hit you up. Might be needing a divorce soon.
All right. Well, I'm the guy.
Yeah. Zach, and for those that are interested, his information is in the description. I mean, what do you got for us?
I was gonna make a suggestion to Zach. I'm sure you have what's it called, business cards, right?
Yes.
I suggest you put a mustache on the T. Yeah. That'll work perfectly.
There we go. I didn't even think about that. I'm gonna have to do that. Like I just bought I just bought a batch like a few months ago, so I'll have to do that with the next batch.
Or a mustache on the backside, right? And then you leave them at the bars, like all these little mustache.
There you go. Yeah, that's my unique brand right there.
Free mustache rides.
There we go.
Well, I want to thank you again, Zach. I appreciate you coming out, and we'll do this again. Guys, with that being said, we're out of here. We'll see y'all next time.
Yeah, thank you for having me. Thank you.